back on the record, this is the people of the state of Colorado versus James Egan Holmes, case number 12 CR 1522. The record should reflect that Mr. Holmes is present with his attorneys and the prosecutors are present as well. We are outside the presence of the jury. I had a little time, not a lot of time, to review the demonstrative exhibit, and these are the slides that apparently the defense wishes to use with Dr. Gurr during her direct examination. Mr. King, why weren't these provided earlier to the prosecution?
Well, Judge, frankly, she just came in on the plane, and I just had the chance to review them and decide which we wanted to use and what her testimony was going to be and the specific relevance of the slide. So, as I said before, we've been in trial here for many, many, many weeks, and for many weeks, the prosecutors came in here and handed us exhibits that they were going to introduce into evidence the morning of the trial, the morning of the testimony of that witness. And that included with all kinds of different witnesses, including expert witnesses. So, I apologize that I couldn't have gotten them to them sooner. As soon as I was able to get them and review them, I sent them to Mr. Brockler so that he would have 3 days to review them, to send them to his experts. If he wants to discuss them with Dr. Gurr over a break before he cross-examines, I have no objection to him doing that, Judge. But that was it's just the trial process, Your Honor.
Mr. Brockler.
I'm sorry, Your Honor, if I could. The simple fact is, whatever exhibits that ultimately got displayed during witness testimony in the prosecution's case in chief, they were all in discovery. You never heard the defense say, we've never seen these before. They're not in discovery. This is entirely different. And Judge, to just add one other matter to this, it's related, but it's separate. Can I bring it up now, Your Honor, or should I wait?
If it's related to this, perhaps you could, or you should.
So last night at about 6:30, after 6:30, Ms. Nelson emailed us additional discovery and additional notes from this expert who's going to testify here in the next few minutes that had not previously been turned over to us. And it is a series of handwritten notes that appear to be made on pages of the defendant's purported journal or notebook. It's inexplicable why those things weren't turned over either. What I'd ask the court, and it's to highlight sort of this last-second approach to getting us information. For that, though, the remedy I'd seek, judges, I can't read her writing, and I'd ask that during a break they ask her to type out, or they type out, what those notes actually say so that they can be of some value to us. But it's hand in glove with sort of the process I think that we've been seeing here over the last few weeks is a rush to sort of surprise us with some information that was clearly available to the expert and to the defense in advance of when it was turned over to us. It just didn't get here, and now we're being told, well, not that big a deal. It's a huge deal for us, Judge.
All right. Is there any objection to providing some sort of transcript of the notes so that they are the prosecution is able to read them?
Yes, no objection, Judge. And just so it's clear, when Dr. Gurr showed up, she had a copy of the notebook that she had in her file. And as we were going through it, she said, oh, this must have been the notebook I went over with Mr. Holmes, because look, I wrote some notes on like 3 of the different pages. And they're very, very brief. It's just a few words, basically with a description of what the symbol means on there, and then a couple of other things. So I have absolutely no objection to that. It's just a very few words. They're completely legible to me. But if counsel can't read them for some reason, I'm more than happy to provide a translation, if you will.
Okay. Without objection, then that request is granted. In terms of the PowerPoint presentation, Mr. King, it sounds like you received the final version or made a final decision on the final version of this on Friday. Is that correct?
Yes, Your Honor.
Did you have some version of it before Friday, though?
I had some version of it, Your Honor, but Dr. Gersh sent me different revisions at different times, and I never had the opportunity, due to her schedule and due to the fact that I've been in trial, to actually discuss the slides with her so that I knew what the relevance was and could select which ones were in fact relevant and should be proffered.
Okay. Well, during the break, I looked at the slides. There's a lot of information in these slides. We're not talking about 3 slides or 5 slides. We're talking about quite a few slides, maybe 20, maybe more. I didn't count them, but it appears
32, Your Honor.
32. So quite a few slides and quite a lot of information on these slides. And I looked at the case law to see whether anyone had addressed this particular issue before, and I couldn't find any case law in Colorado, and I couldn't find any case law outside of Colorado, and there's no rule that I'm aware of that sets a deadline to disclose demonstrative exhibits to opposing counsel. I agree with Mr. Brockler that the preferred practice is to provide them to opposing counsel in a reasonable manner, and certainly more than the Friday before the Monday when the expert is expected to testify. I'm not a proponent of hide-the-ball tactics, and I'm not sure why these weren't provided before Friday. I haven't heard a good reason yet, but I can't find any authority that tells me that there's a requirement that they be provided. And so, given that the objection is not to the content, but rather to the timeliness of the disclosure, I don't have a basis to exclude them. So the request to exclude them is denied.
And Your Honor, I thought that I had made the objection in part based on the content because it was not contained in any part of her opinion. This goes well beyond the opinions that were provided to us. This is an expansion of her opinions.
That wasn't the objection. In fact, at one point during your objection, you said she can testify to these things. So I understood that to mean that you're not objecting to her testifying about the content of the slides. If she can testify to the content, the objection then is to the timeliness of the disclosure of the slides. If there is something in here that goes beyond her opinions, then that's a different objection. I didn't hear that. I didn't understand that to be your objection.
And Judge, forgive me, then I clearly didn't articulate what I was trying to articulate was, one, this is new to us, not just as demonstrative exhibits, but the actual substance of it. And I thought what I intended to say was it would be one thing to testify about this. It would be entirely another thing to show it to them. But this is an expansion of opinions that have been provided to us in 2 separate reports. Actually, there was a 3rd report that was generated as recently as April. And none of these things are contained in there. And so I clearly didn't do a good job of articulating that. But it's not just the timeliness of it. It's the content. I'm ill-prepared to address the content of these slides.
Well, what specifically in these slides is new in terms of content?
Your Honor,
What goes beyond her opinions that were disclosed previously? It can't be everything because some of this just talks about general terms, about schizophrenia and things like that. So it can't possibly be the whole thing.
no, Judge, there are a significant number of slides that rely upon research that weren't referenced, that contain graphs, that contain research related to this, that, and the other in terms of the performance. None of that stuff was disclosed or discussed in any of her opinions or in any of her reports. There's pictures of the brain that have different areas highlighted by different colors and an explanation of this. I mean, the terms prodromal may have appeared in a report, but that is it. There are a number of slides that are clearly based on specific studies, specific research that she wants to get into that aren't referenced in any of her opinions. And Judge, I don't have the 32 pages in front of me right now. The only page that I think that I've seen all the information before on, which I don't think the court would allow to be published, is the first page, which is another title slide page.
You don't have a copy of this slide?
I have it in electronic format, Judge. I don't have it printed out.
Do you want us to make another copy so we can talk about what specifically is untimely in terms of content?
Yes, sir.
All right, why don't we do that? Could you please make a copy? Thank you. Unless you have an extra copy.
I may have an extra copy here, Judge, if I can have a moment.
All right.
Judge, I do have a response to counsel's argument when the time is appropriate.
Thank you.
All right, why don't we do it this way? I want to give Mr. Brockler a chance to tell me the ones that he thinks have content that was untimely disclosed, putting aside for a moment the demonstrative aspect of it. Just in terms of content, things that you think, Mr. Brockler, go beyond the opinions that have been disclosed and the proposed testimony that has been disclosed.
Your Honor, in looking at, first off, slide number 1 isn't relevant to anything. It's just a title slide.
I agree with that, and I was not going to allow the first page, the title page. You know, this is it's sort of a PowerPoint presentation, but she's testifying. She's not giving a lecture, so that first page is not an appropriate demonstrative exhibit. It doesn't. I don't see how it could possibly assist her testimony. It's just a title page that says Penn Medicine, P-E-N-N, schizophrenia, and then he has her name and her degrees and her employment below that, and her contact information below that. So
That was just a title slide, Judge. I wasn't intending to show that.
okay, great.
Your Honor, on slide number 2, there's been no discussion of anything to do with the lifespan of the illness or the treatment challenge related to the illness. Slide number 3, there's been no discussion of...
Okay, hold on a second.
Judge, can I respond to these?
Yeah,
or-
let's go one by one. If that's what we're going to do. All right, go ahead.
Judge, all of the experts in this case have testified about how schizophrenia works, that there's a pattern that is common in schizophrenia, that there's a prodromal phase that can begin months or even years before the onset of psychosis, that the first psychotic episode most often develops when individuals are in their late teens or early 20s. These are not opinions, Judge, that this expert has in this case. This is just background information about schizophrenia and the way schizophrenia works.
So that's what lifespan refers to? It's not talking about the lifespan of a person who might have schizophrenia?
No, it's talking about how the disease works, the fact that the disease affects multiple domains, meaning negative symptoms, positive symptoms, the fact that it's clinically heterogeneous, which means that it involves a number of different symptoms of different things, Judge. And it's just generalized background information, and it's all contained. I mean, she diagnosed him with schizophrenia, and all the experts have testified about what schizophrenia is.
And is that what treatment challenge goes to as well?
Yes, Judge. It's a treatment challenge because it's a difficult disease to diagnose.
Your Honor, treatment challenge can't possibly be relevant to any issue in this case, whether or not it can be treated. That is not an issue in this case. The issue is sanity. If schizophrenia somehow speaks to that from back then, that's one thing. But this seems to go far afield. And I'd point this out too, Judge. When I say these things, I could have asked her about these during our interview months ago had I had this, and we might not have had these objections. I'm learning about all this as the court is.
Well, in terms of treatment challenge, to the extent that that refers to how difficult it is to diagnose, I think it's appropriate. I don't know that talking about how difficult it is to treat it, how's that? I'm not sure that that's what she's going to be talking about, but I'm not sure how that's relevant anyway.
It's just background information, Judge, on how that it's a complex brain disease. It's difficult to diagnose, difficult to treat. I'm not going to ask her extensive questions about how you treat schizophrenia or any treatment that was administered in this area. And I would point out, Judge, in terms of lifespan, on page 3 of Dr. Gurr's updated report, on the third paragraph, she says, considering other diagnoses offered by other mental health experts, she talks about her diagnosis of schizophrenia, and she says, may I highlight briefly why schizophrenia is a diagnosis that best fits the clinical impression from a lifespan perspective, and no other related diagnosis with this category of disorders. So, Judge, these are all information that's background information to her opinions that are in her reports.
All right, Mr. Brockler, I agree with Mr. King on that one. And again, if there's a question, not again, but I'll tell you that if there's a question that's asked that you think is irrelevant or calls for irrelevant information, then object at that point, and if I agree with you, I'll sustain the objection. If I disagree with you, I'll overrule the objection. What's the next slide that you have an issue with? Not the next slide that exists, but the next one that you think we need to address.
Slide number 3, Your Honor. There's a reference here to remission and relapse and some course of psychosis through both of those, which is not spoken about in any opinions that have been revealed to us, nor does it appear to be relevant to any issue in this case.
Mr. King?
Judge, of course it's been spoken about. The course of schizophrenia is exactly what I just referred to in her report. She talks about the course of schizophrenia and how the disease progresses over the thousands of cases that she's studied. And this is common knowledge in the field, Your Honor, that all the other psychiatrists have already testified to this exact same thing. Remission and relapse certainly could be relevant to the issues in this case, Your Honor. We have allegations that Mr. Holmes may not have been mentally ill when he was first incarcerated at all, or that he may not have been psychotic. And there's been testimony from all the experts that this is a disease that waxes and wanes. It goes into remission at times, it relapses at times. That certainly may be relevant to this case. That's not what I intend to ask her about with regard to this slide.
Was that in her opinions that were disclosed?
Yes, Judge, that this is a disease that is fluid, that it waxes and wanes. I remember specifically her discussing that with Mr. Brockler during their interview at length, where she described the psychotic process as being fluid, as changing over time, as waxing and waning.
Did she talk about remission and relapse?
The psychotic process in that aspect, she does, Judge.
She does discuss that where? I
don't know that the exact words remission or relapse appear in her reports as I stand here before you, Your Honor. But those concepts, the concept of how the disease works is discussed in her report. Furthermore, it's just a part of the course of the disease, Your Honor, in general. So it's not that she is rendering some new opinion or anything like that. This is the course of schizophrenia as it generally takes place among the population, and that's been the testimony of the other experts as well.
But I don't recall anybody mentioning remission and relapse. Maybe I missed it. But I don't remember anybody else talking about remission and relapse.
They may not have used those exact terms, Your Honor, but they referred to the concepts in discussing how the disease can wax and wane, how the symptoms may be worse at some times and not as worse at other times. That's what the words remission and relapse mean. They're not offered as terms of art necessarily here. It's just talking about how the disease works.
Is she opining that Mr. Holmes was in relapse when he was, that he was psychotic and that he was psychotic during relapse? Because that's what the graph seems to indicate. It has psychosis under the relapse square.
No, Judge, this graph doesn't relate to Mr. Holmes. This isn't a test that was done on Mr. Holmes. This is just a general graph of the course of the disease and how the red line relates to psychosis, that psychosis may increase and then decrease, wane and then wax and then wane again. And that's the extent of what this says, Your Honor. The psychosis can come and it can go and it's fluid. That's all it says.
Mr. Brockler.
No matter how many times Mr. King says the gist of this was covered, these words are not in any report. I don't recall experts testifying about any waxing or waning of anything in a discussion of their various conclusions or diagnoses. In fact, nobody, except perhaps Dr. Woodcock, talked at all about this being schizophrenia. Dr. Metzner talked about maybe it could be in schizophreniform, schizoaffective, but there was no discussion of remission or relapse, and if that's not an issue in this case, it is not appropriate to have this jury focus on the rest of the life of this mental illness past what is relevant to this case. And Your Honor, this same objection would go to the next slide, slide number 4.
All right, I agree with Mr. Brockler on these two slides. I think to the extent that she's going to opine that Mr. Holmes was in remission and then had a relapse and that he was psychotic during the relapse, then these two slides I think are generally irrelevant and frankly could mislead the jury. So The only reason why this is relevant is if it applies here. To just talk about the course of schizophrenia, just to talk about it, again, this is not a college where someone's coming in to give a lecture. This is a trial. So I understand that sometimes lawyers will use PowerPoint presentations, but there's a limit to that. And I have to be careful that the jury is not misled, and I have to be careful that whatever is presented is relevant. So these two slides I will exclude because based on what I've heard, she's not going to be testifying that Mr. Holmes was psychotic after having been in remission and then relapsing. And if that's the case, then I don't see how these two are relevant. So, all right, what's the next one that you object to?
Your Honor, slide number 5, I simply don't understand. It is some bizarre Venn diagram with a bunch of different circles, some that touch, some that don't, and largely because I haven't had any opportunity to confront any expert with these. I have no idea what this is about.
And Mr. King, I'm assuming that this slide goes to why it's challenging to identify schizophrenia early.
That's right, Your Honor. A main component of the prosecution's case, apparently, is that Mr. Holmes didn't change at all and showed no outward signs of mental illness, according to them. And this bears directly on that issue. And that's something, again, that all of the other experts have testified about as well.
All right, I think that one is fair. What's the next one that you object to, Mr. Brockwood?
Judge, what I'm not sure about is this last bullet point, implicate frontotemporal brain systems. I don't recall any testimony about that, and I don't recall if that appears at all in any of Dr. Gurr's revealed opinions thus far.
This is a slide on neurocognitive deficits in schizophrenia. That's the title of it. Mr. King?
Yes, Judge. You know, this is something that the other experts have testified about too. And, you know, Dr. Brockler is rather disingenuously...
Agreed.
Dr. Brockler, there we go.
You two are fond of making each other doctors.
Sure.
As long as you keep referring to me as Your Honor, I'm okay with it. All right, I think that's fine. There has been testimony about the frontotemporal brain systems and how schizophrenia can affect those systems. So I'll allow that, and I don't think that's that big of a deal anyway. Okay, what's the next one that you object to, Mr. Brockler?
Your Honor, 7, 8, 9, these things make no sense to me. 10, 11, they're all apparently specific studies and accuracy speeds and score speeds that I don't have any idea what they're about.
It starts with the profile one.
Yes, sir.
And then the next one is profile of first episode in previously treated patients, neurocognitive deficits, and effects of education, and then neurocognitive profile.
Yes, sir. And none of these studies, none of these graphs, none of this information has been a part of her revealed opinions.
Mr. King?
And Judge, these are all in her opinions. I'm looking at page 14 of her report. Talks about variability in performance in neurocognitive domains, including verbal memory and executive functions, how these deficits are characteristic of individuals with schizophrenia, and on and on. And so, Judge, these are on these, if you look at the slide that says profile neurocognitive domain, these are the areas of neuropsychological testing that have already been testified to by other experts. And when Dr. Hanlon was testifying, Mr. Brockler seemed to know a great deal about these domains in these areas. So,
is this the profile for the defendant or just a profile in general?
No, Judge, this is a general study that was done of individuals, and you can see on the upper right-hand corner that there's control group, and then there's the men and the women in the test group, and you can see from the graph, the colors, how they scored on various neuropsychological tests, and that it's consistent over time. Individuals with schizophrenia suffer from neurocognitive deficits in certain areas. That's what her opinion is. It's contained in her report. It's contained in her second report as well on page 4.
Did she refer to these studies that she's relying on?
Judge, she did not specifically refer to this study, but she referred to, this is just an illustration. Again, I'm not seeking to admit this in front of the jury. This is not offered for the individuals that were in this particular study. This is general background information that's part of her opinions contained in her reports that individuals that suffer from schizophrenia have, neurocognitive deficits in certain areas. So the question then is, where did that come from, Dr. Gurr? What's the basis of that opinion? How do you know that this is the case?
Right,
and she knows it's the case because she studied it, and others in her field have studied it, and that's what this is an attempt to illustrate.
But my order related to experts was that you have to disclose not only the opinions of each expert, but the basis and the reasons for those opinions. So if this is one of the bases and reasons for her opinion, then it should have been disclosed. Even if the demonstrative slide wasn't disclosed, the study should have been disclosed.
Well, Judge, this is just an example of many. She will testify that the literature is replete with these kinds of studies. It's common knowledge in the area. It's not something that's breaking news to anyone. This is just an illustration of something that's common knowledge in her field, just to give the jury some idea as she talks about, folks that have schizophrenia have deficits in the area of verbal memory. And the jury's already heard about verbal memory. They've heard about what it is. They've heard about how the testing is done. And this is just to illustrate graphically, as she testifies, it affects their verbal memory. We could point to the section on verbal memory and say, look, this is an illustration of how it generally affects verbal memory.
And then effects of education, is that related to the same thing?
Yes, Your Honor, and that's also contained in her reports, both of her reports, where it talks about the impacts of intelligence and education on schizophrenia, and in particular how it changes the manifestation of the neurocognitive deficits that individuals with schizophrenia suffer from.
So the next one is neurocognitive profile, and then the next one appears to be one that doesn't have a title. Actually, the next two don't have a title, but they appear to be related to the same thing. Is that right?
They were related to flat affect, Your Honor, and how flat affect affects individuals with schizophrenia and how it's a reflection of the disease. This has been testified to by a number of the other experts who talked about negative symptoms and how that works. Dr. Woodcock, Dr. Metzner, Dr. Reed all testified about these things. So these are just, again, illustrations of how it generally works to accompany her testimony about these areas that are present uniformly in folks with schizophrenia.
Mr. Brockler?
Judge, these are exactly what the court had thought that they were. These are the bases for her opinions, the data and the studies. There is no reason why, if this was common knowledge, how could this not have been provided to us ahead of time for us to, none of this, by the way, was gone into any detail with any of the other experts. It's as if Mr. King wants to say, well, somebody said schizophrenia is bad, and we have a whole bunch of specific studies that talk about how bad it is, and therefore it was testified to. None of this has been revealed to us through anything other than a potential sentence by Dr. Gurr, an opinion that says it could impact him in some way without going into this kind of detail. I have no ability to cross-examine her on the basis for her opinions based on this data that she's going to testify to because it was never revealed to us. And that goes through slide 13, Your Honor, on all of these things.
I don't have them numbered, so what's the title? Is that on the...
Your Honor, slide 13 has no title. It just starts off, and I'm showing it to the court. It says non-flat at the top and flat with a blue line and a green line.
There are two of those.
Uh-oh. The second one of those, which appears to be an overlay of 12, sort of a redundancy of 12, which was the one right before it.
Is that, again, a study? These two slides on flat and non-flat, are they charts of a study that was done or studies that were done?
Judge, the study is referred to in each slide on the bottom right-hand corner. So this is a study that Dr. Gurr did herself in 2006. It was contained in a peer-reviewed article, which is in her CV and was turned over to Dr. Brockler. So, Judge, for him to say
Hold on, which one was disclosed? The peer-reviewed article that was disclosed is which one?
It's Gurr et al. Schizophrenia Bull is the title. I don't have the CV right here. I could try to find it, but all of her publications are contained in the CV. So all of these studies are referenced in the CV. And if Mr. Brockler wanted more information on them, he could have requested it. There was never any request for any of this information, despite the fact that she discusses these issues in her reports and that he was provided with the studies in the CV. He's known that she's a research scientist for the entire pendency of this case, Your Honor. It's no surprise that she comes in here with knowledge about schizophrenia. She's been studying it her entire life.
I'll allow the slides on flat and non-flat, the two slides, because it sounds like those are based on her own study, and it sounds like that was disclosed in terms of, at least in the CV, indicating that these are her publications. In terms of the 5 preceding slides, based on what I'm told, the opinions were disclosed, but the basis for those opinions were not. And certainly, it sounds like the defense did not disclose that she was relying on these specific studies for those opinions.
She relies on all of her studies for her opinions, and if you're looking at the neurocognitive profile slide, that is reference to a specific study that she did that's contained in her CV.
Oh, that's her own study as well?
Yes, Your Honor, and the other studies that are referenced, for example, effects of education, Swanson et al. Biological Psychiatry, these are studies that are done in her program as part of her research in the program. So she supervises all of these other studies. It's like when we heard about the scientists in neurology at CU, there's a primary, and then there are other researchers that work for them. She's the primary.
Was that disclosed as well?
I can check and make sure that
can
is.
you check?
I don't want to make any misrepresentation.
All right, but the ones that say profile of first episode in previously treated patients, neurocognitive deficits, those you're saying are based on her own study, and it's a study that was disclosed. Is that right?
Yes, Your Honor.
Okay, what about the one on the effects of education? You're checking on that?
I'm checking on the Swanson et al. One right now.
All right, if it was disclosed, I'll allow it. If not, I won't.
Your Honor, may I supplement on the CV part of this? And I know the court's order. I just want to put in the record. She provided a 50-plus page curriculum vitae, and to suggest that that somehow puts us on notice of what she was going to rely upon in forming her opinions would have put on us the burden of going back and going through every single publication and study that she'd done, when instead those were offered as part of a CV. They could have easily been highlighted for us. In fact, right now, Judge, we're trying to go back to see if they're in there. And I'd ask the court to require Mr. King, because of the untimely notice of this, to point out where in the CV that study is,
okay,
so that we can see for sure that we had some remote possibility of having understood that it was going to be testified to here in court beforehand.
That's fair, Mr. King.
Yes, Judge. Well,
Do you know where in the CV it is?
Yes, the Swanson et al. Biological Psychiatry, the effects of education, is contained in the CV on page 19. It's item number 123.
And what about the one that relates to the profile slides?
Oh, that other one was item 129, not 123.
Okay.
And the profile slides...
It says at the bottom, Saykin, S-A-Y-K-I-N et al., 1994. And I'm assuming that all 5 of these are related to that study.
They are, Your Honor.
I said 5. There may be less than that. It's 1, 2, 3. It's 3, and then you have the effects of education slide, and then you have neurocognitive profile again, which is unrelated. So it's actually 3.
Okay, these are not the flat affect slides, is that correct?
That's correct. It's the ones that talk about profile. Apparently, these are the ones that 3R based on Sakin et al.
I have one neurocognitive profile that says Gurr et al. And Sakin et al. I apologize, Judge. One of the neurocognitive profile slides says Gurr et al. 2001. That's her study. We're checking on the Sakin 1994 right now.
All right.
But-
If it's not in the CV, I will not allow those 3 slides.
Okay, Sakin is item number 24 from the CV, Your Honor.
Okay? So it is in there.
Yes, Your Honor.
And then the Gurr et al. 2001 related to the neurocognitive profile, a different neurocognitive profile slide. This one follows the effects of education. Was that in the CV?
Judge, I'm sure that it is. All of her publications are contained in the CV. Every one that the court has asked for up to this point has been contained in her CV. These are all studies that were done under her direction in her program at the University of Pennsylvania. And Ms. Nelson is looking right now to try to specifically verify that, Your Honor.
Okay, that takes us to the anatomy one. Mr. Brocker, do you have an objection to that one?
Yes, Your Honor. There's been nothing about any opinion that she's revealed that goes into the dendrites, axon terminals, Schwann cells. This appears to be something that was generated by enchantedlearning.com. None of this has been revealed as part of any opinion that she has provided.
Judge, this is just a diagram of a brain cell. I mean, this is what brains are made of. This whole case is about a brain disease. This is not prejudicial in any way to the prosecution. We all have these inside our heads, and this is just to let her to describe how brain cells work. That's what she does. She's a psychiatrist and a neurologist, and that's what formed the basis of her opinions.
Is that mentioned in her report, that she's going to talk about brain cells and how the brain works and how mental illness might affect the brain?
Yes, how mental illness affects the brain is what her report is all about, Judge, about how neurocognitive deficits take place and about how, and we've had testimony from other experts about, you know, how the brain works and what different portions of the brain do. And this is all background information for this jury to you know, decide whether her opinions are credible or not.
All right, the next couple of slides appear to be of the same type. Is that right?
Yes, Judge. They're just generalized, a picture of the brain and the different areas of the brain.
Okay, what about this slide that has a bunch of pictures, or not a bunch, but a few pictures?
Well, Judge, the next 1, 2, 3, 4, 5, 6 different slides relate to MRIs. And as you know, the third report that Dr. Gurr submitted in this case was the result of the MRI that we were finally able to get done earlier this year, and her conclusions based on that and the analysis that was done by she and her colleagues of Mr. Holmes's brain. So Mr. Holmes underwent an MRI. We're going to hear testimony about the MRI and what her conclusions were. This first slide is just a picture of an MRI, so that she could say, this is an MRI, this is what it looks like. You put the person in there and we scan his brain. I mean, I see no problems with that at all. After that, these are various...
Hold on, before we go.
Sure.
Mr.
Sure.
Brocker, anything on these 6 slides?
What are we doing now?
Including the anatomy ones, Your Honor?
I'm past the anatomy one. I'm starting at the MRI. The MRI pictures.
But, I don't know that by the way, Dr. Gurr's been present for all this. I should just put that on the record seated in here.
Okay.
I don't know that the doctor knows which one of these MRIs is applicable, if this is just this is what an MRI could look like. She did not administer the MRI. She only reviewed what was sent to her that was done at Presbyterian, I think, or Parker Adventist, I think it was. That's slide 17. Slide 18.
And so you're objecting to this slide with the 3 pictures or 4 pictures? I don't know if it's 3 or 4 pictures. But they appear to be pictures of an MRI machine or several pictures of an MRI machine.
I don't care about 17. Your Honor.
All right. And then
18.
what about the next 5?
18, in terms of the segmentation, I'm not aware of anything in her report that revealed these images previously about this or a specific discussion of this on 18 on segmentation.
All right, Mr. King, is this slide showing results of the MRI and the defendant or
No, Your Honor.
something else?
They're not. These are showing the results of MRIs done on people who are known to have been diagnosed with schizophrenia, to give the jury a point of reference. These are folks that were in studies, again, that she did who are known to have schizophrenia, and it shows the effects of on the brain physically of what schizophrenia does to people who are known to have schizophrenia. And so she, in her report on the MRI, testified that in her opinion that corroborates her diagnosis of schizophrenia because in fact there is a volume loss in Mr. Holmes's brain. The MRI revealed that his brain has essentially shrunk over the time that he's been incarcerated, and that's consistent with the diagnosis of schizophrenia. This allows the jury to see with their eyes how that looks when you do an MRI on someone with schizophrenia, and it's just intended to accompany, again, her testimony about how this works with folks that have schizophrenia.
All right, Mr. Bruckler, I'll allow that one. What's your next objection?
Your Honor, can I say that there is no opinion of hers that has been revealed to us that says his brain has shrunk while he's in jail. That's the first time I've ever heard that. The opinion she's provided is a paragraph that just talks about quantitative analysis. Some decrease in volume, but it doesn't say over what period of time, when it started, when it happened. This is all brand new.
Well, decrease in volume
That's
sounds
her
similar
opinion,
to
Judge.
shrunk. All right, what's your next objection, Mr. Bruckler, after that slide?
Your Honor, slide 19 involves a completely different process called an fMRI, which isn't applicable in this case. Slide
Mr.
19 begins MRI protocol overview.
Okay, I see it. Mr. King?
That does not involve an fMRI. The fMRI slide, Judge, is slide 22.
No, there's at the bottom of that slide, though, that Mr. Bruckler's looking at, it says fMRI resting state.
Oh, I see that. I see that. On the bottom of it, that's right,
Right.
Judge. And what she's attempting to illustrate here is the difference between what you can do with an MRI, which is what was done, and what was done with an fMRI. And frankly, I don't mind not including that slide,
Okay.
Your Honor.
All right, take that slide out then, please.
The next slide is done by intended to show the volume loss, and you know this is not only were they provided with her report that talks about a volume loss, they were also provided with the report of Dr. Davatsikos, who is cited at the bottom of this slide, who is the person, her colleague, that she conferred with and who helped do the volumetric analysis. He wrote a report. That report was provided to the prosecution. It has the specifics so that they can provide it to their, and I know that they hired an expert to give this information too. So we gave them the data, we gave them all of the volumetric analysis, it's all contained.
So this slide is specific to the defendant?
No, this slide is to again illustrate the volume loss, and you can see the 30% atrophy that is being referred to down in this slide down here. So it's the volume loss and where in the brain that volume loss takes place with someone who has schizophrenia. And the importance of that, Judge, is that we've already had testimony from the neuropsychologists that having schizophrenia can involve neurocognitive deficits in certain areas of the brain, and they testified about what those areas of the brain are. Well, the reality is that those areas of the brain correspond to the areas of the brain that show volume loss in the MRIs. So it's a corroboration of the diagnoses is what it is, Your Honor.
Mr. Brucker, do you have an objection to this particular slide that's titled Automated Volumetric Analysis?
I do, Your Honor. It suggests here that there's some 30% atrophy. I don't know that it's even applicable in this case. I presume we're going to get the opportunity to cross-examine Mr. Davatsikos at some point, and we can ask him about these things, but it doesn't look like this is apples to apples with what's going on in the defendant's case. And I should remind the court, too, and the record, this MRI wasn't done back in December of 2012 when Dr. Gurr had the first chance to meet with the defendant. It was done 2.5 months ago. And that was or at least this report was generated 2.5 months ago, days before we began opening statements in this case. So these things haven't been hanging out there for a long period of time with our ability to address them or bring them up to experts. This is shift-on-the-fly, last-second stuff that has come to characterize the presentation of the case by the defense thus far.
I would object to that characterization, Your Honor.
All right, Mr. King, on this one, is there a comparison between what Dr. Davatsikos did and what he found in terms of 30% atrophy in the picture on this particular slide and whatever was found on the defendant's test?
I think that what was found on the defendant's test was less than 30% atrophy, and the indication would be that, and counsel can cross-examine on that to any degree that he wishes to do that, Your Honor. You know, there's certainly an indication that the volume loss is slight in Mr. Holmes, and there's room for argument there. But this is intended to show what the volume loss is in someone who's got schizophrenia and is progressed into the disease. So this is just, again, to illustrate the testimony about what a brain with schizophrenia looks like, and then the jury can compare Mr. Holmes' brain to this and make whatever determinations they wish.
All right, and the paper from Dr. Davatsikos was produced. It looks like there's a reference to some kind of paper or some kind of publication from him in 2007.
Yeah, I believe that would be covered as well, Judge. We can check on that, but we looked back on the Gurr et al. 2001 that you were asking about from the neurocognitive profile. That's item number 165 on her CV. So based on the fact that we've been able to find every one so far, I'm fairly confident that this is in fact, and I know that Dr. Davatsikos works for her because he did the analysis, helped to confer on the analysis in this case.
Okay. All right. I'll allow that one. Mr. Bruckler, what's the next one?
Your Honor, if they don't find this paper, this study, in the curriculum vitae that was disclosed,
I will keep it out.
Judge, and we gave them Dr. Davatsikos' entire CV with all of his publications in it, so they have that as well.
Did he speak about this study, or did he refer to anything in his paper? What did he do in this case? Did he do a report in this case?
He did a report in this case at the request of Dr. Gurr, the same way Dr. Rogers did a report for Dr. Reed, to confer on, to make sure that her reading of the MRI was consistent with his reading of the MRI. She gave it to him blind, didn't tell him who it was, and he looked at it and wrote a one-page report about the volume loss, and it's all quantitative. There's nothing subjective about it at all. It's all a quantitative thing, and submitted that back to her, and we turned it over to the prosecution along with his CV.
Okay. Judge, he hasn't been endorsed as a witness in this case, let alone an expert. And any report that he generated would be an 803 objection on that. So having disclosed a CV to a witness that wasn't endorsed, that's not notice of the foundation and basis for his report. Judge, we don't have the ability to respond to these things.
Judge, it's in her CV as well.
It's in her CV?
It's in her CV as well.
All right.
Item 219.
Okay. I'll allow it then.
She co-authored this study and wrote the article, co-authored it with Dr. Davatsikos.
Okay. I'll allow that slide then. Mr. Bruckler, what's the next slide?
22 is another fMRI study, Your Honor. And that, I'm sorry, Your Honor, it begins with fMRI study.
Oh, I see it. Okay. So we're skipping one then,
Well,
and
which-
then we're coming to the fMRI study. Do you have what's the relevance of this one?
Your Honor, forgive me, I thought that when Mr. King was talking about what had been disclosed in Dr. Gurr's CV, he was referring to 20 and 21.
Oh, perhaps he was.
I was, Your Honor.
Okay, great, thank you. Thank you for that. Oh, you're right. Although it's a different reference at the bottom, this one is Davatsikos et al., Arch Gen Psychiatry, 2005.
I just saw that too, Your Honor. It does look like a different publication. Maybe they'll find that in the CV as well.
All right. Do you know whether that was disclosed?
Judge, I'm sure that it was.
Okay, the fMRI study. The other slide that had a reference to fMRI, you agreed to take out. So are you agreeing to take this one out too?
Sure, Judge. That's okay. I mean, what this, just to inform the court what this is to show, is this is to illustrate her testimony about that people with schizophrenia and other brain diseases actually can think and actually can do things. And this is, there's been a lot of proffered testimony by the prosecution relative to, Mr. Holmes, writing letters, writing emails, being able to go to the gym, being able to ride his bicycle, being able to do all kinds of normal everyday activities. Ergo, he does not have a mental illness. This is intended to show, Judge, that when you give someone with schizophrenia an MRI while they're being asked to do neuropsychological testing at the same time, that it shows that in fact they do think, they just think in an impaired way.
All right, that one is excluded by agreement. The next one is bottom-up processing of emotion.
Your Honor, this is another fMRI study, and there was nothing discussed in any of the reports about this.
Mr. King.
I don't know that this is an fMRI study, but I could be wrong about that. I am wrong. Dr. Gurr informs me that it is an fMRI study. What this relates to, Your Honor, is freezing. We've heard testimony at length in the videotaped interview with Dr. Reed about Mr. Holmes freezing when he was in these social situations. And that's contained in all of Dr. Gurr's reports as well, this report of freezing. This is relates to freezing and how that takes place in someone with schizophrenia, the effect of fear upon their cognition, Your Honor.
Was that disclosed in her opinions or in her report in terms of freezing?
Yes, the issue of freezing was disclosed in both of her reports, Your Honor, and she talks about how its effects is involved with schizophrenia. This fMRI...
But I mean, was it disclosed in the context of how it may show on an MRI?
No, Your Honor, it was not. I don't recall anywhere in either of her reports where it says this freezing, this social anxiety and fear would show up thusly in an MRI. It's just intended to be a graphical illustration of that point that is contained in her reports.
All right, that one will be excluded. First of all, it's an fMRI slide, and I think consistent with the agreement to exclude the other fMRI slides, it should be excluded on that ground. But secondly, and perhaps more importantly, there was no disclosure that she intended to testify about fear or freezing being visible on an MRI. And there's a difference between someone opining about fear or freezing in a social situation based on mental illness and someone opining, on the other hand, about freezing or freezing in a social situation or fear showing in an MRI. So I'll exclude that slide.
I don't object to 24, 25.
Okay.
26, while there's been some discussion with some of the experts about genetics and inheritability, this particular slide with this data or whatever study it comes from has never been disclosed.
This is the slide that has offspring of dual mating, and then MZ, parents, it's I'm going in vertical order, that slide.
Yes, sir.
All right, Mr. King, what's this slide about? It looks like it's a lifetime risk of developing schizophrenia.
Right, Judge. This slide and the next slide relate to the inheritability of the genetic nature of schizophrenia as a brain disease and other associated schizoaffective disorder and schizotypal personality disorder I include when I describe schizophrenia because they're all interrelated diseases. This has been testified to by all of the other experts, and it's throughout her report that in fact, it is an inherited disease, and that is common knowledge in the community. And this is just a demonstration from a couple of different sources of how that's the case. That in fact, it's been studied consistently over time in many studies, and it's uncontroverted in the field that it's inherited, and the prosecution's experts will say the same thing, Judge. And so this is just again a visual way of explaining that to the jury. The second slide, the Sullivan, Daly, O'Donovan slide, is to show the inheritability relative to other illnesses, alcoholism, major depressive disorder, ADHD. So that shows, relative to those other types of problems, how inheritable is this disease. And if your question is going to be, were these specific diagrams provided to the prosecution before? No, they were not, Judge. They're just intended to be demonstratives to illustrate her point that is in her reports.
On the one that has a chart, explain what these categories mean to mean on this slide. I mean, it says offspring of dual mating, and then there's a red line, horizontal red block that goes across and appears to be a percentage. Then there's MZ, then there's parents, then there's DZ. Are these, what's the relationship between the categories and the percentages at the bottom?
This is the percentage risk of getting schizophrenia, inheriting schizophrenia. So offspring of dual mating would be if your father and your mother both had schizophrenia, then you would have that percentage likelihood of getting schizophrenia.
So that would be like 45% or so.
Right, 45%. So this is not something that shows that, if your father has schizophrenia, you automatically are going to get it. It's just a risk factor like any other, like heart disease or something like that. There's certainly room for argument for counsel to argue about how conclusive this is.
But was that information disclosed? In other words, I see a difference between saying, schizophrenia is a hereditary disorder and then having a much more detailed slide that breaks down the percentage of the risk based on whether you have offspring of dual mating, whether your parents have it, whether your siblings have it, whether your children have it, your grandchildren, nephews and nieces, uncles and aunts, whether it's your spouse, and then also comparing it to the general population. I mean, I don't know that if Dr. Gurr is a geneticist, but this seems a lot more detailed than simply saying this is something that is hereditary.
And it is, Judge. It's just meant to place in Mr. Holmes' family so that the jury could place that in there. I don't have a problem with drawing this slide if the court has a problem.
Yeah, that one's coming out.
Your Honor, 27 does not appear to be part of the legal finding. This is curriculum vitae, some other.
It's not.
Consistent with the court's.
I agree, and I think it's one thing, again, to say this is hereditary. It's another thing to say it's hereditary, and here's how it compares to, these other things that are hereditary. I think those two are different things, and if you were intending to have her testify about the latter, then I think that should have been disclosed, and it doesn't sound like it was. It doesn't sound like the study was either.
It was not, Your Honor.
Okay, so then that one's coming out as well.
And so slide 25, just the general genetic liability, there was no objection to. And I was wondering about, there's one that's a little out of context, maybe out of place, domains of cognition. Does the court have that one?
Can you turn it over so I can see it? I don't have that one.
I could withdraw this slide. This is just the different domains in the neuropsychological batteries
Okay,
that have already been testified to by the neuropsychiatrists already. So
great. I only have a handful more. The next one I have is Manhattan plot. Do you have any objection to that one?
That describes some sort of chromosomal dependent illness.
What's this slide about, Mr.
Judge,
King?
that's I would concede that that's true.
Okay.
There's this is a very a very, very common study in this area called the Manhattan plot, which plots out the chromosomes of people who are known to have schizophrenia.
Okay.
And it's just meant to show that that particular chromosomes are consistent over time. So it's an illustration of the same point, that it's inheritable via the genes, and these are the genes that are associated. That's what it shows. So
Right. It's out by agreement. The next one is neurodevelopmental context. Mr. Brockler?
What I don't know of is any revealed opinion or evidence that there was an early environmental insult related to this first bullet point. It doesn't appear in Dr. Gurr's opinion or the basis for her diagnosis of the defendant as having schizophrenia. That's new.
Mr. King, I think this one, I think the comment by Mr. Brockler goes to the first bullet point on here that reads, initial vulnerability to the development of schizophrenia is the result of some combination of genetic vulnerability and an early environmental insult.
right.
So the objection is specifically to the early environmental insult.
Well, there was an early environmental insult in this case. The record is clear through the medical records that Mr. Holmes, when he was born, his mother had gestational diabetes. He also was lodged in the pelvis during the birth process, causing him to have a flattened head, and had to be born by C-section as a result. Dr. Gurr would testify that that may have some minimal impact, but she doesn't feel that that had a tremendous impact in this case. And this is just to show basically that the fact that you have this in your gene pool doesn't mean that you are inevitably going to get schizophrenia. This is an attempt to be fair and to show the jury that this isn't conclusive, and that these are just factors that contribute to the development of schizophrenia.
Mr. Brockler?
Judge, there is absolutely no reference in any report, whether it was generated back in June of 2013 or a couple months ago by Dr. Gurr, that makes reference to gestational diabetes, some flat head thing. We've had no discussion of any of this, and now we're going to bring it in as a discussion topic to quote, and I'm using the air quotes, to be fair. Judge, this is not appropriate to this case. It's irrelevant, and this is a brand new basis for an opinion.
Mr. King, is it true that this was not disclosed?
Your Honor, and maybe I didn't say it right, but what I was going to say is that what Dr. Gurr's opinion is that this was not, in her opinion, a cause of the schizophrenia in this case. So that's out there in the record. I'm trying to deal with that and what her opinion about that, what that was. It's not contained in her opinions because it didn't form a basis for her opinions. Quite the contrary, and I'm trying to just point that out in fairness that although he suffered from some early environmental insult, it's not her opinion that helped contribute to the schizophrenia.
But just because it may be in the records doesn't mean that it's admissible. I don't see what the relevance is. So, and I think it has the potential to confuse the jury and to mislead the jury. I mean, it sounds like you're trying to walk a very fine line and saying, hey, this is a possibility, although she's going to say that she's not opining that that is what happened here, but putting it out there as a possibility. And so I don't think it's appropriate as an expert opinion, even if she's just going to say, no, she doesn't think that's what happened here. But furthermore, this was not disclosed, so it's not appropriate. So that one should be excluded.
Okay. Aside from the slide, Your Honor, that is information that she reviewed. And so I am going to discuss with her the fact that she reviewed those records, and I am going to ask her, did that form the basis for your opinion that he has schizophrenia? And her opinion is going to be no. There are lots of things that she reviewed in the record that didn't form the basis for opinions on schizophrenia. Police reports, all kinds of things, and that's something that's in the records that she did review and did consider, but eliminated.
Well, I don't know if there will be an objection to that question. Mr. Brucker saying yes. I'll tell you that I'll sustain that objection if there is an objection. I mean, you can't just ask a question because something's in the record and just say, oh, but that didn't form an opinion. Now you put it out in front of the jury. It doesn't work like that. So I don't see why this is relevant. It's not, if it's not the basis of one of her opinions, it's not relevant. I mean, she can say, I reviewed all the records. I went back and reviewed everything that was provided to me, all the medical records. She doesn't have to get into how, at the time he was born, this happened, and as a result, there had to be a C-section, and as a result, there were some consequences to him. I mean, that's irrelevant. So the slide is excluded. The next one is a general prediction model. Is there any objection to this one, Mr. Brockler?
Would the court forgive me, since we're on that line of discussion right now, if the court looks at not general prediction and not the next neural developmental model, which I have something to say about, but that last slide,
okay,
that is the same thing that was talked about in the slide that the court just excluded, which is this environmental insult, this intrauterine environment stuff. None of that has been disclosed as the basis for any opinion, and it should be excluded as well.
All right, Mr. King, anything from you on this?
On this last slide?
Right.
Judge Jed, this is the way that these are the factors that influence the development of psychosis in individuals generally.
Okay.
So that's what this is intended to show. And Judge, on the point of things that she considered that didn't form her opinion, this court allowed the jury to see 20 some odd hours of videotape from Dr. Reed, and that's most of which didn't form the basis for his opinion. So I would note that. But this is just a generalized diagram of the different factors that go into the neurodevelopment of individuals with schizophrenia in general.
All right, that's a comparison of apples to oranges. I mean, allowing the jury to see Dr. Reed's evaluation almost in its entirety is completely different than allowing an expert to go into some records and not only going to, in general, say, I looked at records going back 21 years, but to get into the contents of some specific records that by her own admission have no relevance to her opinion, just to get the information out there in front of the jury, I think that's improper. It's not the same thing. And by the way, there were some things in Dr. Reed's examination that I excluded at the request of the defense because I agreed with the defense that that information was not appropriate, at least not at the guilt phase of the trial. So this last slide, for the same reasons I stated earlier, is excluded. It goes into this idea of environment during young adulthood, adolescence, intrauterine environment, those kinds of things. And perhaps the young adulthood and adolescence may have some relevance, but in terms of the prenatal stress and the early environment and the intrauterine environment, those things by Dr. Gurr's own admission are not relevant to her opinion and do not have any significance for any of her opinions, and I think it's improper to get that in front of the jury. So that slide should be excluded. All right, that's all of the slides, I believe.
And Your Honor, I just skipped over 30 and 31 because we were on the topic of that intrauterine environmental insult thing, but if I could revisit 30 and 31 just to...
Okay.
30, Your Honor, I don't see how it's relevant. It's not information that was previously disclosed. I don't know that it's part of anything that was disclosed in the CV. and there's been no discussion in her reports of any multimodal maturation index. And then, Judge, looking at, again, just to speed things up, on 31, I don't see that this has been disclosed to us either. It appears to be some article from Nature magazine from November of 2010, and it doesn't look like that's been disclosed to us either. I don't know if that's part of the CV. We looked, we couldn't find it.
All right, Mr. King, do you want to address these last two slides? It's the last two in terms of our discussion, but for purposes of the slides, it's the penultimate slide and the one that immediately precedes it.
Because I have no objection to withdrawing 30.
Okay, that one's out.
But the last slide, I think, is important in that it shows changes in the brain happen during normal development and are different when exhibit to illustrate.
At the bottom of this, it says that this slide or the information comes from INSEL, I-N-S-E-L, and I may be mispronouncing it. And then it says 11 November 2010, and then it says Nature. Apparently Nature magazine is what I think Mr. Brocker said. Was that disclosed?
The specific Nature magazine page, no, Judge, but the matter contained in here is yes, is discussed throughout her opinion. Testimony for the jury and let them understand how these things work.
Right, but these graphs come from this particular source, and I think opposing counsel is entitled to challenge the source of the information, if you will, and that's why I always require the parties to produce not only the opinions that you anticipate, but also the bases of those opinions. And so if she wants to testify that these graphs accurately reflect the gray matter volume changes and the differences between someone with a normal brain and someone with schizophrenia, then that should have been disclosed. That's one of the bases of what she wants to talk about, and specifically the comparison and how different they look. That's something that should have been disclosed, so they could then look into it and be ready to challenge it or perhaps question her about it on cross-examination. So it doesn't sound like it was disclosed unless you found it.
No, this is the primary focus of her research. It's all through her CV. It's all that her opinions are all about. This is just a picture from Nature magazine to help her to describe how that works. So this is not the basis for her opinion, Judge. Bases for her opinion are her lifelong research that she. This is just something that she. The bases of her. Eligible to them. So what? Say, this based on this, I concluded Mr. Holmes has schizophrenia, or this is the basis for my opinion. Quite the contrary. We were just going to show it to the jury and say, explain how this illustrates what your opinions are about how volume loss occurs in people with schizophrenia.
Right, but it's not, in that sense, it isn't just illustrating her opinions. He may be consistent with her opinion, I don't know, but this is from a different source. This is not from her own study. This is from a different source, and if that source had taken her study and had said, okay, based on her study and her research, then here's what it would look like on two graphs, and here's a comparison that would apply. that's not what you're saying, right? You're saying this is an outside source that came up with these graphs on their own in terms of the differences between a brain that is normal in normal development and a brain of somebody who has schizophrenia. So that seems to me that that's more substantive than what you made it seem to be or what you made it sound like. And if I'm misunderstanding, then let me know. But, it would make a difference to me if this outside source was looking at her research or perhaps a study that she conducted, and if they would simply be illustrating her conclusions. That would be one thing. And I would say, well, they're just illustrating what she researched and what she concluded. This is different. This is an outside source that apparently came up with their own conclusions about what the differences are in terms of two graphs between a brain that is a normal brain, normal development brain, and a brain of someone who has schizophrenia. So, these are not just, these appear to at least for an untrained eye like mine and like the jurors' untrained eye, it appears to be more scientific than that, and it appears to be more specific in terms of the measurements than that. And so I think it's a slide that, number one, violated my rule on discovery of expert testimony, and number two, could mislead or confuse the jury. So that one should come out as well. All right, that takes care of all these slides. And you can mark them all as a court trial exhibit at some point. All right, are the parties ready for the jury?
Yes, Your Honor.
What I was going to do is just bring them in, have them watch the videotape, D-TR-95, then take our lunch break for 1 hour at that point. Is that all right with you?
Given the delay, Your Honor, because of the arguments, et cetera, I think we would prefer to publish the video after Dr. Gur's testimony so that we can get started with her and get her testimony going.
All right, well then do you have a preference between whether we take a lunch now or if we start with her, it'll be for about 25 minutes and then we'll take our lunch break at that point.
I think it makes sense to just take the lunch break now unless the court feels strongly.
That's fine, we can take a lunch break. Let's bring them in and let me talk to them, please. Please be seated, everyone. The record should reflect that the jury's back in the courtroom. I'm not going to give you a lunch today. No, I am. Actually, we're going to go ahead and take our lunch break now, but I wanted to bring you in, let you know that. I want to thank you for your patience. There were some things we needed to talk about outside your presence. We're done talking about them. And so, and again, from time to time, there are administrative, scheduling, and legal things we have to talk about without you being present. And it's just part of the process. But I very much appreciate how patient and understanding all of you folks are. I think what makes the most sense, rather than start with the next witness for a little bit and then take our lunch break, is to just go ahead and take our lunch break now. So that's what we're going to do. We're going to take a lunch break. If it's okay with you, I like to take an hour instead of an hour and a half. I'm still looking to have the case to you for deliberations early part of next week. That's my goal. And so I want to keep us on track to meet that goal if we can. So let's take an hour to make up a little bit of the time that we've lost today. And then let's have you back at 20 till 2. All right? Please make sure that you abide by all my admonishments during the break. They all apply. And all of them, as you know, are extremely important. All right? Enjoy your lunch. I'll see you back here in 1 hour. The record should reflect the jury has exited the courtroom. Please be seated, everyone. Let's go ahead and take our lunch break for 1 hour, and then let's plan on starting with Dr. Gurr at 20 till 2. Is that all right with everyone?
Yes, sir.
All right. Mr.
Yes,
King?
sir.
Okay, great. I'll see you back in an hour. Thank you. The court will be in recess.